All rise.
Thank you, ladies and gentlemen. You may be seated. Court is in session. Ladies and gentlemen, this is a first hearing in juvenile case number JV 2016-12. The title of the case is In the Interest of Betsy Smith, a Minor Child. Mr. Garrett, would you introduce the participants in the courtroom?
Thank you, Your Honor. My name is Tyler Garrett, District Attorney representing the state of Wyoming in this matter. With me at counsel table are Sarah Serrelson with the Wyoming Department of Family Services, as well as Officer Jenny Craig with the Sheriff's Department. Also present is Aaron Hockman, the guardian ad litem for Betsy. Also present is Whitney Smith, the minor child's mother, and Kevin Smith, the minor child's father, is in jail but is on the phone.
Thank you, Mr. Garrett. Mr. Smith, you're on the telephone. Can you hear me okay?
Yes, sir.
Very well. Folks, as I indicated, this is a first hearing in a juvenile case. I'm Judge Couts. I'm one of the district court judges here in this district. And in Wyoming, district court judges are also juvenile court judges. This is a hearing in juvenile court, and it's important that you understand that because there are some differences between what happens in regular court and what happens in juvenile court. One of those differences is that these proceedings are confidential. And there's some other differences I'll tell you about in a moment. Mr. and Mrs. Smith, there are two purposes for us being here today. First, the law requires me to go over with you why we're here and to be sure you understand what's going on. So that's the first purpose we're going to cover. The second purpose is to consider whether it is necessary for your daughter, Betsy, to remain in the temporary custody of the state of Wyoming to protect her welfare. That's called shelter care. So we're going to review each of those things. First of all, I want to talk about your ability to understand me today. Are each of you able to understand me okay so far?
Yes.
Yes, Judge.
Do either of you have any disabilities that would make it hard for you to participate in this hearing or understand me?
No.
No, Your Honor.
Have either of you been using any sort of medicine or alcohol or drugs?
No.
No, Your Honor.
Very well. Well, as I go through the matters in this hearing, if there's anything you don't understand or if you have a question, please ask me. All right, Mr. and Mrs. Smith, we're here today because the state filed a petition that claims that Betsy is a neglected child and an abused child under Wyoming law. Do each of you have a copy of that petition?
Yes.
Yeah.
Very well. Basically, the effect of that petition is an accusation against the two of you, and it alleges that the two of you have failed to provide adequate care for Betsy, that would be neglect, and that you placed her in imminent danger, and that's the accusation of abuse. The petition has some separate accusations against each of you. Against you, Mr. Smith, the petition alleges that you are incarcerated and so obviously unable to care for your daughter, and that the home your daughter lived in was of such a state, such a bad state, that it fails to adequately meet her needs and places her in imminent danger. For you, Ms. Smith, the accusation is the same about the home, that the condition of the home was such that it failed to meet your daughter's needs and placed her in imminent danger. And there's a separate accusation against you that you were intoxicated to a point where you couldn't adequately meet your daughter's needs. So those are the accusations against the two of you. Do either of you have any questions about those accusations?
No.
No, Your Honor.
Very well. Mr. and Mrs. Smith, when the state files a petition alleging that you have neglected or abused your daughter, there are some rights that apply to you under the law. And I'm going to go over those rights with you to be sure you understand them. First of all, under the law, your daughter is presumed not to be neglected or abused. That means that you don't have to disprove these things. Instead, the state has to prove that these accusations are true. In this case, the state has to prove the accusations to be true by what's called a preponderance of the evidence. That's more probably true than not, and that's different than a criminal case, and these aren't criminal charges, but nevertheless, the state does have the burden of proof. You have the right to deny that these accusations are true. You never have to admit them. And as I mentioned, if you deny them, the state will have to try to prove that the accusations are true. The state is required to bring this matter to a trial quickly, within 60 days from today. You have the right to be at any trial. You have the right to see and hear the witnesses and evidence used against you. You have the right to cross-examine the state's witnesses or to have your lawyer do that for you. You have the right to ask for an attorney, and if you can't afford an attorney, you fill out paperwork that shows me that, I'll appoint an attorney to represent you. Mr. and Mrs. Smith, I told you that you have a right to a trial within 60 days from today. You can have that trial before me as a judge, or you can ask for a jury to decide whether or not these accusations are true. If you want a jury to decide this case, you have to file a written request for that jury within 10 days from today. Otherwise, I will just hear the case myself. In this case, if your daughter turns out to be abused or neglected, what could happen is that the state could be required to set up a plan to try to remedy whatever has gone on. The goal in juvenile cases at the beginning is always to keep families together or to put them back together if that's possible. The law in Wyoming strongly prefers that parents raise their children and that children live with their parents. There are a couple of circumstances when that goal can change. And one that you need to know right away is that if your daughter is placed in the custody of the state in foster care and she stays there for a period of time that lasts 15 months, and that could be 15 months all in one chunk or at separate periods of time adding up to 15 months out of 22 months, in that event, the law requires the state to file a petition to ask that your parental rights be terminated. It's important that you know that so that you do whatever is necessary to get your daughter back and to put your home back together before that time period runs. The second circumstance that could come up to change the goal in this case is if you just fail to cooperate or fail to do whatever is necessary to provide adequate care and safety for your daughter. In either of those circumstances, the goal could change at some time down the road. On that second circumstance, there would have to be a hearing before me before the goal could change in your case. If your daughter is placed outside of your custody, even for a temporary period of time, you could be required to pay child support to the state of Wyoming for the period of time that she doesn't live at home with you. If your daughter is found to be abused and neglected, the law requires me to appoint a group of people called a multidisciplinary team. And that is a group of experts who would know about you and your family, and they make recommendations to me about what should happen. Now, I don't have to follow those recommendations, but if I don't, I have to have good reasons why I don't, and I have to explain them to you. Also, the law requires, if you have abused or neglected your daughter, the Department of Family Services to conduct a complete investigation of your home. And things could come up in addition to whatever is alleged in this petition. And if that comes up and those things need to be addressed for your daughter's welfare or safety, those could become part of the juvenile case as well as these specific accusations. So, Mr. and Mrs. Smith, that's an explanation about what could happen in your case and some of your rights. If you ever disagree with what has gone on in your case, you have the right to appeal, to ask the Wyoming Supreme Court to review what I've done or what has gone on in your case. Ms. Smith, do you feel that you understand your rights?
Yes.
And Mr. Smith, do you feel that you understand?
Yes, sir.
Please tell us what happened yesterday.
My partner and I went to the Smith residence to serve an arrest warrant on Mr. Smith. I knocked on the door. Mr. Smith answered the door. I asked if he was Mr. Smith, and he indicated that he was. I informed him that I was there to arrest him. He indicated that he had expected this, that he knew that the police were looking for him, and he asked if he could call his wife, Mrs. Smith, to come home to take care of the baby, Betsy. I gave him permission to go ahead and call his wife. He left the door to the house wide open, and so while he was on the phone, I was able to look inside the home and observe what was going on. And I saw the baby crawling around on the floor, and the floor was covered with animal feces everywhere, particularly in the area where the baby was crawling. I also noticed that there was an electrical outlet very near the area where the baby was crawling around, and that there were many exposed wires coming out of that electrical outlet. A few minutes later, Mrs. Smith arrived at the house. She stumbled up the stairs. She had bloodshot eyes. When she began speaking to Mr. Smith, her speech was slurred, and I could smell the distinct odor of alcohol on her. At that point in time, she seemed very agitated and angry at us and at Mr. Smith. And so my partner went ahead and arrested Mr. Smith and took him to the car. And at that time, I took the child into protective custody.
Mr. and Mrs. Smith, now I'm going to give Mr. Hockman, the guardian ad litem, a chance to answer any questions he has of this witness. Now, the guardian ad litem is an attorney appointed to represent your daughter. Doesn't represent you, but he represents the best interests of your daughter. Mr. Hockman, do you have any questions for this witness?
No questions for this witness, Your Honor.
Thank you. Mr. Smith, do you have any questions you want to ask this witness?
No, Your Honor.
Very well. Ms. Smith, do you have any questions?
What the officer said is not true. I admit I had a few beers yesterday, but I was not drunk. I'm not drunk now, and I promise not to drink again. Can I have Betsy back?
Hold on, Ms. Smith. I need some additional information, and we need to do it in the proper format. So we're going to go through one witness at a time, and we'll ask questions of that witness, and I'll give you a chance to make your statement to me and tell me your position as well. Do you have any questions for Officer Craig?
No.
Very well. Mr. Garrett, then would you please call your next witness?
The state calls Sarah Sarelson with the Department of Family Services.
I met with and interviewed Mrs. Smith yesterday in her home right after Betsy was taken into protective custody. At that time, the home still had considerable safety hazards, hazardous items in the home that were concerns for Betsy to remain. I was able to meet some with Mrs. Smith. It appeared at that time she was under the influence of alcohol. Her speech was slurred, her eyes were glossy. She had a very hard time having that discussion. She was cooperative at that time with DFS and has continued to be. We were able to meet this morning. We started to develop a safety plan to address some of those items that we're concerned about with returning Betsy to the home. She is working on engaging a safety network to be able to help and monitor with the safety plan. And so at this point, we continue to have concerns with Betsy returning to the home today. However, with the safety plan developed, safety network to monitor, we would at that point recommend that Betsy would be able to return to the home.
Ms. Sarelson, can you tell me what you've done to locate any extended family?
Yes, Your Honor. Yesterday, when I met with Mrs. Smith, she discussed having family that was in California. The family has recently located here, and so I was able to contact both maternal and paternal relatives that are out of state. We are working on getting supports that are in town so that she's able to have supports with her, and we have begun the ICPC process looking at different placements, but at this point there isn't anyone located in town who could be a placement option.
Very well. Mr. Garrett, do you have any other questions for this witness?
No, Your Honor.
Mr. Hockman?
No, Your Honor.
Mr. and Mrs. Smith, do either of you have questions for this witness?
No.
No, Your Honor.
Mr. and Mrs. Smith, the court has heard evidence from the state, and I've heard argument from Mr. Garrett, and I've heard your positions. Now I'm going to ask the guardian ad litem for his recommendation as to what we should do about shelter care. Mr. Hockman?
Thank you, Your Honor. Prior to this hearing, I interviewed Mrs. Smith and the Department of Family Services caseworker and believe that with an adequate safety plan, the child can be returned to the care of her mother. The mother is employed, has child care in place while she's at work, she's committed to not drinking alcohol while she's watching the child, and understands that the house needs to be clean and made safe. I would recommend that the court continue protective custody, place the child in the legal custody of the Department of Family Services with physical placement for foster care. However, I'd request this court grant DFS the authority to return the child to the physical custody of the mother once a safety plan has been completed and agreed to by the mother. The safety plan should address the cleanliness of the house and the repair of the exposed wires. It is in my client's best interest that the safety plan be completed as soon as possible and no later than 24 hours. Betsy should be returned to her mother as soon as possible and would request that this court set a deadline of Friday. Thank you.
Thank you, Mr. Hockman. Ladies and gentlemen, the court has heard the evidence, testimony, and argument today, and now I will make findings and a decision for you about shelter care. The court finds that it is contrary to the welfare of the minor child to remain in the home with the parents at the present time. And the court finds that the evidence establishes it is in the best interest of the child to continue in protective custody pending the development of an appropriate safety plan. The court finds that DFS has made reasonable efforts to prevent or eliminate this need for placement, including trying to locate relative placement. The court finds that DFS is making reasonable efforts to reunify the family through the development of an immediate safety plan. The court orders that the minor child be placed in the temporary care, custody, and control of the state of Wyoming for placement in foster care until a safety plan is completed. Once that safety plan is done, Mr. and Mrs. Smith, the child shall remain in the legal custody of DFS with physical placement back with her mother. We will revisit legal custody at a further initial hearing, which I am ordering to be set in 10 days. Mr. and Mrs. Smith, each of you is ordered to cooperate with DFS and develop a safety plan within 24 hours. DFS will file a signed safety plan with the court. I expect Mr. Hockman to monitor the case progress and to notify the court if the child is not to return to her mother by Friday. Mr. and Mrs. Smith, I have ordered that you cooperate in this case plan. Earlier, I told you that this is not a criminal case. However, when the court makes court orders in a juvenile case, if you fail to comply with them, you can be subject to contempt of court, and that includes possible jail sentences. So it's very important that you comply with all court orders in this matter. The court will order a potential adjudicatory hearing to be set within 45 days. Thank you very much, ladies and gentlemen. Court is adjourned.